Had you for an hour just before this. It was in camera. We asked some good questions and we got some answers. And so for the interest of transparency, I'm going to kind of re-ask similar questions and hope that we can get the same answers. Now, I noted that under the CSIS Act for their threat reduction measures, that you have to get a warrant in order to move forward from the federal court. It's not clear under this legislation whether the government would need a warrant to move forward with the actions that they're giving themselves the power to do. Why is that?
Thank you, Mr. Chair, for the question. So the powers under C8 concern the ongoing regulation in terms of the security of underlying infrastructure. So in the instance of telecommunications, it's Bell's network infrastructure. They do not engage with certain charter rights or privacy considerations in that context. That's similarly how telecommunications operators are currently regulated. So, for instance, in the allocation of spectrum licenses that are necessary to run their wireless networks, that's currently an authority under the Minister of Industry. And there's no need for judicial oversight. So
we talked about a specified person in the previous hour, and you told me that they're a legal entity, not necessarily a natural person. There's a concern that when you have legislation that's written to say that the minister has the authority to order the telecoms to cease providing services to a specified person, there's a fear that we're talking about individual Canadians. Can you provide us with, if you believe an individual Canadian is a threat to the telecommunications system, there was degrading the system, disrupting the system, manipulating the system, why is there no requirement for a warrant in that case?
Thank you, Mr. Chair, for the question. In the context, if I understand the question correctly, for instance, in the regarding the authority to withdraw services from an entity. In that context, so first of all, the authorities are scoped in terms of needing to protect the Canadian telecommunications system. So that means that the individual commentary of Canadians or their ongoing traffic online is not germane to that, just in practical terms. So that would be in the context, for instance, of a distributed denial of service attack, which is flooding a network and preventing essentially the operation of it for other Canadians. The use of that authority needs to be reasonably necessary to advance the stated goal. So it can't just be on a whim. It needs to actually be tied to the gravity of the threat that's in question. And we are dealing with circumstances that where time is of the essence, where these are services that Canadians rely on for life and death, be able to call 911 or to do things of that nature. And so there are considerations about being able to move quickly.
Why the secrecy? Why are there the secrecy provisions provided in this?
Thank you, Mr. Chair, for the question. So generally speaking, the secrecy provisions are both not necessary and not operationalizable. So when we're dealing with equipment that applies to all telecom carriers, 99.9% of the time, we're going to be going out with a public consultation with rules, and we want everyone to know the rules of the road. There can be some specific circumstances where, for instance, an operator has a vulnerability in their network that's very specific, where disclosing that vulnerability would essentially invite hackers to flood the zone while that operator is trying to get that under control. So that's the use case for the confidential order-making provision. It does include oversight, for instance, notification requirements to NCIRA and NSICOP so that they have line of sight and ensure that the power is being used appropriately. It's also subject to the annual reports to Parliament. So even though—
Is there an opportunity for judicial review, if somebody feels that these decisions are infringing on their charter rights?
Certainly anyone can go to the courts with an application of judicial review. And
but what if it's secret? Like if they've been ordered that they can't say anything, how would they go to the courts?
So we still need to consult the affected parties. Like that's a bedrock. That's a provision of the bill, and it's also a bedrock provision of administrative law. So, like though the entity affected still needs to have the opportunity to make their case about how the order may affect them, and they can go to the court. As well as, again, the notification to review bodies and the annual report to Parliament, which even if it doesn't disclose the individual, like the detailed nature of the order, still needs to describe the activities as well as their necessity.
Is there a time limit on those things? Like it says specified time. I only have 10 seconds left.
Yes.
So.
We have 90 days to notify and Sirenense COP, and the report to Parliament is tabled annually.
Thank you, MP Lloyd, for these good questions.
Really well, aren't we? So there's been some groups like the Canadian Civil Liberties Association that have talked about encryption standards. There's a fear that this legislation will give unprecedented powers to break encryptions. Is there anything specific in this bill that deals with encryption-breaking powers?
Thank you, Mr. Chair, for the question. So there isn't a specific provision governing encryption. However, the ability to break encryption for the purposes of surveillance is out of scope of the powers here. Being able to access individual information for the purposes of law enforcement is certainly an important issue. It's a very hotly discussed topic. We've seen in C2, for instance, but it is deliberately out of scope of this bill. For instance, breaking encryption does not advance the protection of telecommunications network infrastructure. It just has nothing to do with that.
No, thank you for that clarification. I think the argument that has been advanced, and I apologize to these organizations if I've mislabeled their argument, but they talk about the term that the minister can order the telecoms to do anything or refrain from doing anything. And they're saying that that's a very broad kind of power that could lead to the breaking of encryption. Can you kind of describe why that power has been worded? I even thought to myself, like, that seems like a very interesting wording to use, refrain from doing anything or doing anything. It seems very broad.
Thank you, Mr. Chair, for the question. The wording is meant to capture the range of risks to the telecom infrastructure that can exist. And so, for instance, one may want to tell a service provider that they cannot use a particular product or service in their network, or that they need to take some positive action to protect their network. But again, a bedrock principle of statutory interpretation is that you need to look at the bill as a whole. For instance, the policy objective at the outset, sets the overall scoping. There are additional requirements, for instance, that the order-making power needs to be reasonable to the gravity of the threat, et cetera, et cetera. So those all still apply and structure the government's ability to act.
Thank you. And we talked about personal data. You've said it's outside of the scope of this. We've kind of gone over that. But the Intelligence Commissioner has stated in testimony that this power of the minister to ask the telecoms or to do something or refrain from doing something could give them the ability to ask the telecom providers to provide the private information of Canadians. And I believe the Privacy Commissioner has also raised this concern. Can you elaborate on those concerns, and are they a concern, and why not if not?
Thank you, Mr. Chair, for the question. So the Information Collection Authority in Part 1 is modeled off of the existing Section 37 of the Telecommunications Act that has been in place for decades without incident. It just carried forward because it needs to be applied to the new security network protection authorities. It is still structured within the scope of what can be done to protect the Canadian telecom system and not to advance general security or law enforcement aims. So it is still limited to the order-making authorities and the protection of Canadian telecom systems, as opposed to, and cannot be used to advance a generalized fishing expedition or, investigation into personal information.
Thank you. And in my final time, how is it determined if the minister's decision under this powers is reasonable? Who determines if that's a reasonable thing that the minister has done?
Thank you, Mr. Chair, for the question. So at the outset, first there is consultation on the rules, and we are required to take into consideration what those views are. And then there are notification and transparency requirements after the fact, and then ultimately all decisions of the minister are reviewable by the courts. And the telecom operators are not shy to go to the court. They are, well-resourced and frequently make use of that avenue.
Good afternoon, Chair and members of the committee. Thank you for inviting us today to discuss Bill C-8, an act respecting cybersecurity, amending the Telecommunications Act, and making consequential amendments to other acts. My name is Bridget Walsh. I'm the Associate Head of the Canadian Centre for Cybersecurity, also known as the Cyber Centre, within the Communications Security Establishment Canada. I'm joined by my colleague, Danielle Couillard, Director General Partnerships and Risk Mitigation. Le Centre pour la Cybersécurité est l'autorité technique.
The Cyber Centre is Canada's technical authority on cybersecurity. We lead the government's federal response to cybersecurity events, and we serve as a unified source of expert advice.
To discuss Canada's cyber threat landscape and the importance of cybersecurity in the context of Bill C-8. I want to begin with a simple truth. Our world has never been more connected. From the smartphones in our pockets to the satellites orbiting above us, from the smartphones above us, technology has woven itself into the very fabric of our daily lives. It powers our communications, our economies, our healthcare systems, and even our democracies. But with this unprecedented connectivity and reliance on technology, we are exposing ourselves to its vulnerabilities. Whether it's the risk of state-sponsored cyber threats, the exploitation of aging computer systems, or the misuse of artificial intelligence, this interconnection brings with it a complex web of challenges that touch every sector and every Canadian. Aujourd'hui, les auteurs de menaces peuvent contourner.
Today, threat actors can bypass traditional foreign interference and espionage methods by deploying sophisticated, malicious activities with unprecedented reach, all from the comfort of their homes. In fact, through cybercrime as a service platforms, and with a few strokes on a keyboard, anyone with the means to do so can quickly conduct large-scale campaigns to steal sensitive data, disrupt or deny services, and influence public discourse.
In our 2025-2026 National Cyber Threat Assessment, we are increasingly concerned about the enduring resilience of global cybercrime as adversaries refine their methods, embrace new technologies, and collaborate to expand their reach. Mr. Chair, I have a copy of the threat assessment report with me today, available for committee members. The evolving threat environment requires thoughtful and forward-looking measures. Strengthening Canada's cyber defence capabilities is essential, but so is fostering meaningful collaboration between government and industry. By working together, we can move toward a more proactive approach to threat mitigation. To support this, a comprehensive incident reporting framework would help ensure Canada remains responsive and resilient in the face of increasingly sophisticated cyber threats. Le projet de loi C8 s'appuie sur son prédécesseur.
Bill C8 builds on its predecessor, Bill C26, to advance Canada's comprehensive whole-of-society approach to cybersecurity.
CSC will gain no new authorities. This legislation will provide the government with tools and authorities to enhance cyber defenses and protect critical infrastructure. It will establish a regulatory framework for baseline cybersecurity of critical industry sectors, facilitating information sharing with the Cyber Centre, and allowing regulators to seek CSC advice and guidance. Bill C8 underscores the importance of mandatory incident reporting by reinforcing the Cyber Centre's role in helping organizations resolve incidents and improving collective ability to detect, respond to, and prevent cyber threats through sharing of cyber threat information. The signalement des incidents nous aide à comprendre.
Incident reporting helps us to understand what transpired, share threat indicators, and strengthen our defenses. The information that the Cyber Centre would receive from designated operators under Bill C8
de nature technique
would be strictly technical
mettra l'accent sur les
because it would focus on indicators of compromised and exploited vulnerabilities.
In closing, let me leave you with this. Cybersecurity is a shared responsibility, and if there's one lesson we've learned in cybersecurity, it is that no single entity, whether an agency, a government, or a company, can succeed alone.